co-facilitate our, what I hope is just going to be a discussion today. And, well, let me just tell you a little bit about myself very briefly. I'll let Cynthia introduce herself, and we can talk about how we might want to move forward with this afternoon at the end of the program. Because we know you've sat through, is it 2 hours already? An hour and a half. Did it feel like 2 hours or it feel like 1 hour? I just settled. So my name is Laura Unflat. I'm a sole practitioner. I practice exclusively family law in Wellesley. And I've been doing LAR since it came out as a pilot program, and I probably should have looked this up, though you can probably tell me from your training, whenever it came out as a pilot in Suffolk Court. And I've used it, fairly regularly since. It doesn't mean I use it with all my cases. I don't use it in a lot of cases. But what I've come to do over time is to think about them when I meet a new client. To think about the idea of unbundling, think about the idea of discussing with the client LAR. So what I hope to accomplish today with you in this discussion is to just talk about my experience in using LAR for my practice and just some practice tips. But I hope it is going to be a discussion and for the most part a Q&A, although we're going to start with slides. We don't want anybody to get nervous about the slides. These are absolutely great handout that Cynthia has prepared. We know that some of it you've already gone through, so don't be fearful, but it's another reminder to you.
And I'm Cynthia McCausland, and I have a family law practice in Norwood and practice almost exclusively LAR. And I'll talk more about that as I go through, but I do find it as a way of kind of tapping into a client base that may not be able to afford the $5,000 retainer or $10,000 retainer, but can certainly come up with money on a monthly basis or on a per appearance basis, and certainly doesn't qualify for the pro bono services that are available. So you kind of have access to this niche of clients, especially as a solo practitioner, but certainly in a small firm as well, that can really kind of open up your practice and give you another client base. I wanted to just use the slides briefly, like Laura said, just as a kind of framework to structure our discussion, and I would certainly hope that anyone who has a question as we go along could certainly raise up your hand, and we'll kind of engage in a conversation and not try to talk too much at you. So LAR was obviously developed primarily in the probate courts and has certainly grown since then as a way of giving access to those clients, like I mentioned, who may not be able to afford the initial kind of $5,000 or $10,000 retainer. So although there are many different ways of using LAR, whether it's just helping a client with a financial statement or asking some general questions, I often use it on a per appearance basis. So it allows me to kind of hop into a case without fear that I might get caught in some sort of a web and never be able to get out again if the client stops paying, or sometimes clients get a bit cranky, or if I just stop enjoying the client as much as I may have initially enjoyed the client. Laura, how do you often use it?
In the same way. Sometimes I'll have somebody come in and the idea of plunking down a $10,000 retainer is a little overwhelming for somebody. And of course, if the case is, you don't know early on if a case is going to go to trial, but my engagement letters do provide for a whole separate retainer plan if the case goes to trial. And again, that can be very overwhelming. To discuss with somebody the idea of handling a particular portion of the case tends to free up people a little bit more and make them feel more comfortable on both ends of the relationship. So I find people are much more likely to retain you if they aren't fearful of trying to get a $10,000 retainer together, but rather something that is a little bit more realistic and that I can anticipate better than when a person comes in and says, well, how much is this divorce going to cost? In an initial consultation, it's really hard to know what it's going to cost. People are often just not sure how their spouse, if it's a divorce, how their spouse is going to react, or how the other parent of their child will it in fact be a contested custody matter? What is exactly involved in the case? And I found over time that some people either highly exaggerate cases or exaggerate them one way or the other. I mean, the other extreme may be, I'm sure it's going to be easy. We don't really have much. We've all heard we don't have much, but still people find a way to fight over what little they have. And so it does make it easier for a client to say, okay. I also think with an attorney involved and can be helpful in negotiating the process of a divorce, for instance, up to and including particularly the pretrial conference or temporary orders, something concrete, an event, I think increases the chances that a party may be able to settle. So while I have found on an economic basis, it's been fabulous for my practice because I'm getting paid, with a great deal of ease. I think it's also just an access to legal services. So I feel on a public policy basis, it's just a fabulous thing. More people are inclined to hire attorneys when they're not committed to paying more money than they feel they can comfortably afford. And I think they're getting settlements with an attorney a lot faster than they would without, being a pro se litigant in the probate and family court.
Yeah, and I'll often say to people, like Laura's point about saying that people come in and they're a bit fearful. You have a client says, how much is this going to cost? I feel like, oh my God, what am I getting myself into? But if you can say to the client, I'll often introduce it as a way to kind of limit the liability on both sides. So as attorneys, sometimes we may charge a slightly, a retainer that's a bit more to kind of give ourselves a cushion in case, the client runs out of money, the client stops paying, something is going to take longer than anticipated. And I'll say to the client, by giving you a flat fee on a per appearance when I can kind of hop out after, I limit my liability and I can charge you, I don't have to kind of cushion my retainer. I can charge you what I anticipate it costing on this day for this purpose, and then I don't have to kind of pass that extra liability on to you. And I find that clients really appreciate that, in any circumstance when you're just being super direct and saying, this is what it is and here's how it can help both of us. It does tend to really put them at ease. And they, and when they think, okay, well, I know that I need you for the status conference, but maybe I don't need you for the pretrial conference. They're not feeling like they're going to have to buy into something that they might not want the whole way through. So that can be really helpful.
I should mention a difference in our practice then, or at least part of it, is I never charge flat fees. I still use LAR on an hourly basis only. So maybe we can each talk to that, because I think the idea of a flat fee for many prospective clients is great. I just personally don't do it, but it is certainly a way of doing it.
Yeah, so I call it the hopscotch or pay-as-you-go practice. So a client, oftentimes, and I'm sure this is common for a lot of folks in the room, folks come in and they filed their divorce, maybe they've had an initial temporary orders hearing, but there's still, there's a status hearing or there's a review or there's a pretrial conference, and they think, oh my goodness, like Laura mentioned, this is dragging and I want it to resolve and I can't quite do it by myself. Or there's this issue that I could really use some help settlement with, and they kind of call an attorney at that point to come in. And you kind of know, from speaking with your client and also from your past experience, what does it require to adequately and competently prepare for a pretrial conference, to get the facts and the information for the financial statement and for the memorandum, how much time am I typically spending in the courthouse for that day, how many times will a client typically call me. You kind of come up with a bit of a menu to kind of charge that flat fee, and that's how I do it. And then I find I can't say, your divorce is going to cost X amount of dollars, but I can say, Mr. Smith, this appearance will cost you this much, and here's what you can expect from me, and here's what I can expect for you. And again, I think that clients are always asking for more information, and we always say, probably, likely, hopefully. We're always kind of hedging. It depends. So the more we can say, you look somebody in the eye and you can say, this is what it will cost, this is what I would do for you. I can't guarantee that we're going to reach a settlement, but these are the steps that I'm going to take, and then my experience these types of things have been helpful. And clients appreciate that. And they say, I live to, check, but I had a little extra that I saved away, and kind of over time I can come back, in 3 months for the next appearance. And, I think that they like that kind of discreet quality about it. How do you handle the hourly rate? If do you kind of run out? Are there any differences in how you handle the LAR hourly versus a regular retainer?
No.
Yeah.
Except I can accept a lower retainer because I'm not thinking necessarily too far into the future. With a regular client, I have to assume that I'm representing them up to the trial. As I said, my engagement letters provide for a different retainer if the case is going to trial. And I put things in there about, how to add more, replenish the retainer if necessary, etc. But in the case of LAR, I just have a better idea how much I think it's going to cost. So the retainer is going to be simply a lot less. So that makes it, just a little bit easier for them to even come up with the money initially. And then I bring it down, it just works out of my IOLTA account. As it turns out, unless I can settle the case early on or during that appearance that I've made for them, it's not unusual for me to, let's say, be retained for temporary orders and then be engaged again, re-engaged for pretrial. So, the money's already in there. I may ask for more money. I also will accept payment plans of sorts, because even if it's a less amount of money that I'm accepting as my retainer, or that I anticipate for a particular event, they may still not have the money. Because you just don't know how long you're going to be in court. I was in court this morning, theoretically, just to get a quick trial date. We weren't going to be able to settle. It was quite clear. So the other attorney and I agreed right from the start, let's go in, we'll get a trial date. We'll ask the judge quickly what he thinks. We'll get a trial date, and the judge said, oh, there's one more thing that you can think about. Now go out there and consider it. So it could have been an hour, but it turned out to be 4 hours. So it varies. And this morning was, in fact, another LAR case, and I'm sure that the person will retain me we did get a trial date, but it's not for many, many months. And I'm sure she'll retain me at this point to continue to negotiate. Hopefully, I'm sure we will settle the case, but just a matter of when. So from the start, she puts into my account, or sends a check to me every month, and so she's sort of building up her retainer account, her IOLTA.
How do you handle, so you're in this situation where you've entered a limited appearance for the pretrial, and you're anticipating potential negotiations going forward between now and the scheduled trial date. How do you handle the appearance forum and your appearance at the court, but also your relationship with opposing counsel?
That's a great question. She's a plant. So today I filed my notice of appearance and my notice of withdrawal. I hand both of them together to the clerk, and more often than not, they will accept it, especially now. It used to be early on, they'd say, oh, no, you can't give me your withdrawal yet. You have to wait for the end of the hearing. But that's just too cumbersome. I mean, you're all practicing attorneys, to get back up to the clerk after you've just left, and you have everything that you're taking into account that the judge just said. So I file both at the same time. So I'm out of the case right now, technically, according to the judge. But I always communicate, and I gave opposing counsel my notice of appearance and my notice of withdrawal. But I would say to him, if we can't settle, it's more likely than not, I will continue in the case. And I will let you know if I'm not continuing in the case. And when I file my envelope, I put my address on it. I don't put my client's address on it, because I feel anything that comes about from the pretrial or any appearance, I still have responsibility to make sure it's communicated to the person, and she understands, in this case today, she understands what the judgment was, what the order was, what whatever comes in the mail from that. And then if I haven't already, it depends what the event is that I initially had, I may have already anticipated a post-pretrial continuing negotiation, so I may have already addressed that in my engagement letter.
Yeah.
Otherwise, I just get a new engagement letter. I just send a new engagement letter.
So a lot of it is really managing the expectations with the client and also the court and also the opposing counsel, but leaving yourself open for this relationship that you've created with the client, that you don't have to just kind of fall off the side. Because do you find, of course, we always want to have good relationships with our clients and engender those warm, fuzzy, good lawyer feelings. But do you find that there's a difference in how you present your services or how you present your work to a limited assistance client versus a regular client?
Well, hopefully never how I present my work.
No, but how you present your services and kind of in your working methods and so on.
I think in the initial conversation, it depends. You can get signs from how they're hearing what's happening, whether or not LAR might be appropriate to address. Although I've been, and I might want to, for my own purposes, not from a financial perspective, but, I will speak very candidly, although I think they were on candid camera as well. Sometimes there's a client, particularly in the family law context, they're going through a very difficult time. You don't have a lot of time to really get to know the client and how well you are, in fact, going to work together moving forward. So I might suggest it because I'm not sure if this is going to be a good long-term match for either one of us. And so setting those expectations early on, I think, is best for everybody. So I might early on say, what I can do, there's this unbundling, and I will explain the LAR process to them and give them some opportunity to question a little bit more or think about it further. I can help you draft complaints, and that's something I think people often forget about. It's not all about filing a notice of appearance necessarily. You may not actually be going to court. Sometimes people just need you to help them, and as long as you've disclosed it, it's fine. So if you do any pleadings that you're not signing with your own name, but still assisting, to just put on there, and I know the court has forms that don't necessarily provide for you writing anything extra, but you just have to either handwrite it in or find an old-fashioned typewriter to say, prepared with the assistance of counsel. You don't have to put your name, and they don't have to reveal your name, but you do have to disclose that it was prepared with the assistance of counsel. And sometimes they just feel better about it. So it really varies. Sometimes clients are much more confident than others.
Yeah.
But I've been trying to bring it up a little bit more, just so people understand. Very similar to, you might discuss other, alternative dispute resolution possibilities, mediation or conciliation or collaborative law, none of which I actually do in my practice, but you get a sense from your initial consultation that maybe this is something they might want to consider with someone else.
Yeah. Have you ever had an experience where you kind of, I know, right?
It's become a Q&A between the two of us.
We know each other pretty well, eh? We're both learning. I haven't in the past done a lot of ghostwriting or signing pleadings because I'm always a little bit scared or nervous about what if I put something in there that they don't fully understand. You kind of explain things to people, and I'm big on having people countersign letters. So, you hand them a letter, often I'll mail the letter, and I'll say, can you review it and sign it and send it back to me? So I have some sort of acknowledgement when they have selective memory loss, kind of 6 months forward. But with the ghostwriting, one concern I'm always a little nervous about is I explain it, I do my countersign letter, we talk about what's in there, what the pleadings are, and they call me and they're like, I followed this, but I don't totally get it. Do you have any thoughts on that in terms of ghostwriting or?
Well, I'll answer your question, but I will
Yeah.
also say, whenever I ghostwrite something, I file it.
Yeah, that's interesting too.
I'll have the person come in and sign it, because I'm not signing it, but I do want to make sure what goes to the court is what I have prepared to go to the court, because, a little bit of a change might make a big difference. And I don't want it presented as if I prepared this, and then this other change was made without me knowing about it. But again, the way I view LAR is not too different than how I deal with any other client.
Yeah.
And I think if you keep that in mind all the time, it's a safe route. So for instance, we many times have clients who you feel that you've explained quite thoroughly, but they still come back and say, I never knew that there was a pretrial that required an in-person meeting in advance, and I never knew about this memo that you had to write in advance. And you say, well, I did send you the order from the court, and we explained it, we discussed it. It's just like any other client. You need to know your client and how best to communicate with your client and what your client needs to understand.
Yeah.
It's just a general good practice tip, I think. You just need to know your client. Sometimes you have to eat the cost of that extra time that it's going to take to write either a CYA letter or more comprehensive email, instead of just saying, great day in court today, let me know if you have any questions or if you want to discuss it further. That's a nice quickie, but some people need, this is everything that happened today, even though they were there. But you know what your client may need.
What do you think are the biggest pitfalls?
Not communicating. Did they discuss communication a lot during the training? No. I'm sorry?
I just saw it here on the.
Yeah, we have.
Oh, yeah, no, I mean, her handouts are incredibly thorough. I'm just wondering if during the regular training they discussed it, because I do think that's the biggest pitfall, is the communication. Communicating exactly what you are going to do, what's expected of you, having them really understand. For instance, showing up the day of court and giving them on that day for the very first time your notice of appearance and your notice of withdrawal, might be a little overwhelming for them. They've got a lot on their mind, they're thinking about court, and now you're saying that you're withdrawing. I like to send it to them in advance, even if they haven't signed it in advance. It's a PDF. They can look at it, and just as a reminder, technically, when we leave court, I will no longer be representing you. However, you can still engage me again, or if we haven't finished negotiating, I will certainly continue to do that. Let's discuss it in advance. This way I know how I'm going to present myself to opposing counsel, before the hearing and then immediately following the hearing. And the communication extends not only to the client, but also to opposing counsel. And I just think that that's a bit of a courtesy. I don't think most opposing counsel even focus on the fact that you're here just, here today and gone tomorrow. Some are better about thinking about it, but they'll still call you anyway in 3 weeks and say, okay, so where are we with this case? Well, we're nowhere. I don't have a retainer. But it is good as a courtesy, to follow up. And once you've prepared some of these letters or emails, you can do save as or, copy and paste. And to me, it's just about courtesy, but also keeping yourself a little bit on the cautious side. So, dear attorney so-and-so, just as a reminder, I filed my notice of appearance and withdrawal when we were in court. I have not been engaged thus far. If I am engaged to handle the next appearance, I'll be in touch.
Yeah, and I find too, sometimes you get an opposing counsel and I'll pick up the phone and say, I wanted to touch base ahead of our hearing. I'll be entering a limited appearance on behalf of so-and-so. And they'll say, oh, it's a limited appearance. What does that mean? And just kind of educating, because I think lawyers are still kind of understanding what is LAR and how can you use it and how are people using it. And just to let them know, not to be the jerk who's just going to kind of fly in and fly out again, but just to extend some kind of professional courtesies. Do you have a minute? Do you want to chat about it? I haven't entered the appearance yet, but if you're comfortable having a conversation now, just kind of familiarizing, each other with our positions and seeing if there's anything we can do ahead of the court date. Just like you would with any other opposing counsel. I think that, generally the courtesy is really appreciated. Goes a long way.
Well, I also, let me just finish this thought before I forget it. I also will sometimes be engaged only to handle the pre-court negotiations. Maybe helping with some pre-hearing discovery, for instance. I mean, what can be more overwhelming for a client, a lay client, than discovery? It's hard to even understand what that is. So I may call an opposing counsel and say, I've been retained by Cynthia in a limited assistance. At this point, I'm not going to file a notice of appearance. And the other attorney, more often than not, of course, wants another attorney, because it's difficult sometimes to negotiate with the pro se. And so I can say, and then it takes the same characteristics as any other opposing counsel relationship. Sometimes they're a little leery about it. What do you mean you're not going to file a notice of appearance? What makes me believe that you have even any authority? Yeah. And it depends on what the situation is, but I can say, you can still negotiate with me, and I'll make sure the client gives you whatever authority is necessary. It hasn't happened too often that an opposing counsel will say, no, if you're not going to file a notice of appearance, I don't want to waste my time. And on those occasions, it's often been that their experience is the opposing party, my potential client, has not either committed or followed through on promises maybe that they've made, or they've flaked out in some fashion or another.
Yeah.
I guess what you just said goes to my question of how do you deal with the situations where either before you've been engaged or these roles been engaged, your client has done something that's been damaging to their case, and how do you kind of address that?
So you're out of the case?
Right, like either before you're even engaged, they've been dealing with, say, the other side person and they have not been, and they've been nightmare. And then, or the times where you were just there for temporary orders and you now not there until they want you back for trial, and they've been a nightmare this week. So how do you kind of address those situations with your clients?
I may not take the case. I have to weigh it, and that's the nice thing about LAR. I think you have to have some type of strong, maybe not very strong, but a little bit of a strong constitution to be really direct and really stand by